Hi, everyone. Welcome to the Power Hungry Podcast. I'm Robert Bryce. On this podcast, we talk about energy, power, innovation, and politics. And we're going to get a lot of politics and energy today with my guest, Phil Goldberg. He is the special counsel for the Manufacturers Accountability Project. Phil, welcome to the Power Hungry Podcast.
Thanks, Robert. I really appreciate you having me on today.
So now I warned you, and I'll just give a brief introduction. You are representing the oil and gas industry against a whole bunch of climate lawsuits that have been filed against it. That is what the Special Counsel for Manufacturers Accountability Project is. But guests on this podcast introduce themselves. So imagine you've arrived somewhere, you don't know anyone, you have 60 seconds. Please introduce yourself.
Sure. So as you said, I'm special counsel to the Manufacturers Accountability Project, and we speak not just for oil and gas manufacturers, but for all manufacturers because of our concern with these lawsuits. What they are trying to do, essentially, we can get into this a little bit more when we get to the substance, is to try to make manufacturers have to pay for what are really societal and political issues rather than something truly where the liability makes sense. I've been doing that for several years. I'm also a partner at the law firm of Shook, Carty and Bacon. Before that, I spent 20 years on liability related public policy work, worked on the Hill for a few years. And so I kind of bring that background of understanding sort of the intersection of politics and liability policy. And really what my job and my goal is to try to help make the liability system work in a way that is common sense to all of us. There are people that try to push the liability system out of whack, whether it's for money or to advance political issues, both of which are present in the climate litigation, and try to help the system reach a fair result and be used for the right reasons. I've done work with the Progressive Policy Institute on civil justice issues for that reason, because the goal is to kind of make the system work right, if that helps.
That helps. It was more than 60 seconds, but there's no penalty here. So Phil, it's okay.
I'm a lawyer. I talk long.
Yeah, well, I'm certain. And these are complex issues. But if you don't mind, let me just do a little quiz. So you're based in Washington, D.C.,
Yeah.
and the former law firm you said was Shook, Carty and Bacon. I'm not familiar with that one.
Yeah, Shook, Carty and Bacon. It's where I currently work. And it's in that role. Well, at Shook, I also serve as special counsel to the Manufacturers Accountability Project. And we're a big, AmLaw 100 firm with offices in, 16, 17 cities around the country, and seemingly adding one, every week or two, and about 500 and more lawyers, and mostly known for product liability defense work, but really any kind of high stakes litigation our firm gets involved in.
I got you. So you're a trial lawyer. You work at the courthouse.
I do more appellate and policy level. We've got our firm does a lot of trial work. We're probably do trial work than anybody else, but my job is more on the dealing with the broader liability issues and dealing with them at the appellate court and legislative levels.
Gotcha. Okay. Well, there are a lot of law firms in America, and I wasn't familiar with Shook, Carty and Bacon.
Yeah, we're based in Kansas City, so it's
okay. All right. So 500 law firms, and you're a partner there?
Yes.
Okay. Yeah, got it. Okay. And where are you from? Where did you go to law school?
Oh, I grew up in New Jersey, so I've got that East Coast mentality, and obviously working for a Midwestern firm, it's always fun. But I went to law school here at GW, George Washington University School of Law, while I was working on the Hill, and then when I got my law degree, I started doing more of the liability policy work.
Gotcha. Okay, so let's dive into this climate litigation. I just wanted to because I didn't. I looked up a lot of the stuff. I didn't get your personal bio though here. So the latest, if I can, maybe this isn't the latest, but I know there have now been a couple of dozen lawsuits that have been filed against the oil and gas industry, as well as the coal industry. I know Peabody Energy is one of the defendants, but one of the more recent ones was Multnomah County, Oregon. They filed the lawsuit. It's styled Multnomah County versus ExxonMobil et al., suing the companies for $50 billion. The claims are for public nuisance, negligence, fraud and deceit, and trespass. Defendants ExxonMobil, Royal Dutch Shell, Chevron, Motiva, Oxy, Anadarko, Space Age Fuel, I've never heard of, Valero, Total, Marathon, Peabody, Koch Industries, American Petroleum Institute, Western States Petroleum Association, McKinsey and Company, and Doe's 1 to 250 inclusive. I've never seen that in a lawsuit. So this is one of how many. Let me ask the first question, because I wanted to just get that in the context for why this matters now. Is that the Multnomah County, Oregon case is the most recent one, if I'm correct. But how many lawsuits now are pending? How many of these are you involved in that are have been filed against the oil and gas sector or the energy sector and U.S. energy sector in general?
So there's probably close to 30 overall. It was about 24 as of 2-3 months ago. But there's a coordinated effort by foundations and attorneys and lobbyists, public relations firms to try to bring these kinds of lawsuits. And they've been very active in going around the country trying to recruit counties and municipalities and saying, hey, we can try to get you money. It's not going to cost you anything. Just sign on the dotted line and, we'll bring this lawsuit for you. And so, for a lot of communities and elected leaders, they, ostensibly it's like it's a free kick, and they feel, and if they want to do something about climate change, or if there's an issue, they can say, oh, we're doing something. But the truth is that these lawsuits aren't really doing anything. They're just a distraction from what really needs to be done in terms of trying to deal with climate change and make meaningful progress on it. And that's
but the stakes here couldn't be higher. I'm sorry to interrupt, but it just seems to me, Multnomah County, there are 3,000, 400, 500 counties in the U.S. They're asking for 50 billion. Every county gets 50 billion. Who's going to produce oil and gas? I mean, there seems to me if the potential damages here for the energy sector in general, love them, hate them, whatever, that this could be the bankruptcy of every major energy producer in America. Could it not? Or am I overstating things?
I don't know that you're overstating things, but I also don't think it should get to that, because I don't think the lawsuits are founded either in the facts or the law, and I don't think at the end of the day that they're going to be able to prove their case. They're right now they see a victory in just filing a bunch of these lawsuits, because what they want to do is to put the industry on their heels and try to use the public relations and all the things that come with the litigation and the words that they said were to hurt them politically and try to silence them and make them less able to go to Congress and talk to American people about what they want to do about climate change and how they're working on things. And so they're bringing all these lawsuits and hoping they can find a judge somewhere that allow some of these theories to go through. But at the end of the day, I mean, even the Supreme Court that has ruled on this, 13 years ago, or 12 years ago in 2011 said, these kinds of cases are not what the courts are for. These are policy decisions that need to be decided in Congress and EPA. And it's a good thing we have these agencies that are experts in figuring out how to deal with energy policy. And so what these groups are trying to do, and they've said this, so it's their own language, is they want to use litigation to raise the price of energy. They want all of us to have to pay more to put fuel in our car and to turn on our lights and power our factories, what have you, because that's their solution. That's one of the things that they want to see.
So I have to interrupt there, Phil, because I think that's a key point. And I've said it many times. Expensive energy is the enemy of the poor. I mean, just full stop, right? So who has said that their effort is to? Can you point me to that they're using this litigation to increase the price of energy? Because I think that is a key, absolutely a foundational point here. If this is
the lawyers that are involved in the Boulder, Colorado lawsuit have said, on radio and in papers that that they want to raise the price of fossil fuels through this litigation, and it's their way of holding, in their words, consumers responsible for climate change. And we just fundamentally disagree with that's an appropriate solution for many of the reasons that you just said, because it's incredibly regressive and is sort of an elitist view of how to deal with climate change.
Well, and that's the part where that I think elitist is the right word here. But let's dive down into the details here, because I think this is critical, and a little bit of background. So the manufacturers account, done a little bit of homework here. Manufacturers Accountability Project is a project of the National Association of Manufacturers, a nonprofit. The budget, I just looked it up. I've spent a lot of time on GuideStar and ProPublica. National Association of Manufacturers, an annual budget of about $62 million. The key here, it seems to me, is this: the first claim is public nuisance. And what you have said on the MAP lawsuit, and if you want to find out more about this, you go to mfgaccountabilityproject.org. That's mfgaccountabilityproject.org. Public nuisance theory, I'm reading from the website, though, has nothing to do with regulating global energy supply, and the notion that these communities are entitled to financial compensation while using the very products their lawsuits demonize is nonsensical. Piecemeal lawsuits are particularly counterproductive. That seems to me, if I'm boiling down your whole reaction to all of this, is that not the gist of the whole thing? That these companies, these entities, whatever, whoever they are, they're using the products and blaming the companies for providing the products. Is that, have I simplified it too much here?
No, I think you've hit the nail on the head. I mean, I think we all agree that the way we have used energy, sourced it, used it, is going to have to change. I mean, electrification through these energy sources was one of the greatest achievements, and has been seen as one of the greatest achievements of the 20th century, from refrigeration to a lot of other things. The way we've done that is going to have to change. We're going to have to find a way to make modern lifestyle, more sustainable for the climate, but we're also going to have to do it in a way that is sustainable for real people. And that takes innovation. That's not you can't do that through litigation. We're going to have to find ways to innovate how we source these energies in ways that are much more efficient. And that's fine. And we accept that. And the industry is working hard at that, as are a lot of other people. A lot of manufacturers are making tremendous progress on exactly that proposition. But that's the way we're going to deal with climate change. It's not going to be these lawsuits that are just trying to make it more expensive for everybody else.
But the potential damage here, well, let me shift gears here a minute, because there was an important ruling in April. The Supreme Court rejected, I'm just reading from the E&E News report on this, rejected a batch of climate liability petitions from oil companies, which the article says paves the way for a flood of lawsuits against the industry to be heard in state courts from Maryland to Hawaii. So you said that just a few minutes ago that the Supreme Court ruled in 2011 against this. Why is the April decision germane here? Why does it matter now? If the Supreme Court has already said, no, you can't do this, but there are now lawsuits have been filed, and bring me up to speed on why this, what was the petition and why did it matter?
Well, that's a great question, and I'll try to do my best in keeping it short. So this is it's in the second wave of climate litigation. The first wave started in early 2000s, went through 2011 and 12, and that's where there was a case where you had a bunch of states suing the utility companies, saying, "Hey, you're causing climate change, and you should have to do certain things because of that." And that's the case that went up to the Supreme Court. It's called the AEP versus Connecticut, and the Supreme Court said.
And so just so I understand, this was so that they were suing the electric utilities.
Yeah, there were six
and this was AEP, American Electric Power versus Connecticut.
Yes, exactly.
Okay, right. Thank you. Go
ahead. And there were 3 or 4 other lawsuits at the time that were filed. One from an Alaskan village called Kivalina was suing a lot of the oil and gas companies. You had California AG that was suing the auto industry, and you had a class action in Mississippi suing a bunch of the energy companies relating to damages from Hurricane Katrina. And so the one against the utility companies went up to the Supreme Court, and the court said that, and it was brought under, this is important, it was brought under federal public nuisance law in federal court, seeking injunctive relief. And again, it was against the utilities that were considered the users of fossil fuels. And the court threw that out, the Supreme Court threw that out, saying that's not the right use of liability law. The legal ruling was this has been displaced. The federal common law here has been displaced because Congress delegated how to deal with climate change to the EPA through the Clean Air Act. And so this is not a liability issue for the courts; it's a policy issue
For Congress.
for Congress and the EPA. And so at that time, the Kivalina case was pending, and the Ninth Circuit said, well, if that's the case with AEP, just because the issues are presented slightly differently here in Kivalina, we're going to, that shouldn't matter. We're going to follow the Supreme Court. The Fifth Circuit did the same thing in the Katrina case, and then the California case had never really gotten far against the oil industry, and then it was over. And so then you had the people kind of behind these lawsuits, the foundations, the academics, the lawyers, got together in California in 2012 and said, well, now how do we use the courts to drive our energy policy? We're not happy with how things are going in Congress or EPA, so let's do this again. But we have to make it look different from AEP versus Connecticut, or else the courts will just throw it out. So instead of bringing a federal public nuisance law, they went to state public nuisance law. Instead of seeking injunctions, they sought damages. And they kind of went through and tried to make it, again, look different, and said, but the key to the whole thing is getting into state court. Maybe we can find a judge who won't follow the federal, U.S. Supreme Court ruling and say, well, these are different enough that I don't have to follow that. Because every time these cases, even in the current round, has gone to federal court, like the second court, the U.S. Court of Appeals and the Second Circuit looked at the substance of these cases, they've thrown them out. They said these are not, AP versus Connecticut said these are not good lawsuits. These are no different. These are, you can't show causation. You can't show, these are policy issues, all the reasons that, as to why these lawsuits should fail. And dismissed that. That was New York City's case, which was filed in federal court. All the other cases,
and so just so that was the New York City versus Exxon case, right? That
exactly.
at the end, who was the lawyer for ExxonMobil? Ted
Boutros, probably.
I'm not sure. Anyway, but right at the end of the lawsuit, right in the final arguments, the New York City apparently just folded their case, and apparently I don't remember all the details, but essentially said never mind. Like I'm not remembering this, but perfectly here. But jump back to
there's actually two different lawsuits, but yes, you're right. Okay. There was another one, yeah.
Okay, so but tell me, so you've the objective, and I want to come back to the 2012 meeting that you just referenced, because I want you to understand who's behind all this litigation. But so you've given us the background on the 2011 ruling from the Supreme Court, shift in tactics by the NGOs to try and still come after the energy sector to go through state court. But why does so I'm just trying to abbreviate where you're going. Why does the April decision from the Supreme Court matter? Because then it seems like they're going back on what they ruling back in 2011.
So the law is a funny thing. Is essentially the answer.
Right. So and we only have an hour here, Phil.
No, I know. So they filed all these cases in state court, and the energy company said these are the same thing as AP versus Connecticut. These are federal issues. They're federal legislative issues. They're not state liability issues. But in order to get into federal court, there's a whole bunch of different things that they need to do. And a lot of the circuit said that, the local communities brought these estate law claims, and they're allowed to do that. And we can't just take them into federal court just because, we want to. There are certain bars and standards, and that they're not met here. And ultimately, the Supreme Court just decided not to get involved. They said, there was the energy companies petitioned to the Supreme Court to say, hey, can you check on this? What the Court of Appeals are doing, and letting saying these cases can go back to state court. And the Supreme Court said, we're not getting involved right now. And so they declined to review the case. And so now, as a result, all these cases in April, which the industry was trying to get into federal court, are now all going back to state courts to then proceed at the state court level. So these cases have been filed since 2017. Not one of them has had an issue on the merits, that other than the one in the Second Circuit. I was saying that, but none of the ones in state court have reached any merit-based decision. It's just been this procedural thing of whose ballpark are we playing in? Are we playing in the state court ballpark or the federal court ballpark? And now, as a result of the Supreme Court saying, hey, we're not getting involved right now, the cases went to the state court ballpark. And that's what has led to a few additional filings, because I think people were kind of waiting to see what was going to happen with that.
Okay, so if I'm reading this right, then what you're saying is the Supreme Court said, well, this isn't ready for, we're not ready for this right now. So this litigation is going to have to proceed through the state courts before we're going to take it on. But
That's
that's
right.
a,
I mean,
but
and they
that's a,
may or
but
may
that's a,
not take it on, but we like to think they would. If there's a liability finding here, depending on what happens, we would think the Supreme Court would want to get involved and say, what we said in AP versus Connecticut should apply to these cases as well.
but in the meantime, then the oil and gas industry is going to have to pay a lot of money to people like you to litigate in Multnomah County and in all these other places, because, and that's going to be incredibly expensive for them because they're going to have to deal with all of this litigation at the various state levels before it's ripe to be appealed to the federal courts. Then is that, do I have my strategery here correct?
No, I think that's probably right. I mean, that's why we were trying to get, a uniform national response to this litigation, which could be done in federal court, as opposed to having this done, piecemeal, ad hoc in various states, sort of, and in various versions of these lawsuits. I mean, a lot of this is like, throw a lot of legal spaghetti on the wall and see what sticks. These cases are being brought under various legal theories. They're targeting it's not like it's all the same companies. It's various companies, different combination permutations of them. They're trying to see. It's like a legal laboratory. Can we get a state? What formulation of these lawsuits will work? It's a lot of it's political. They want to name out of state companies a lot of times, not necessarily in state, but then they name some in state so they can get in state court. There's a whole lot of machinations that go behind the scenes about how this litigation proceeds. So some cases are against one company, some cases are against 30 companies. It's so political as to who the local political figures want to blame for climate change. And that's
so who are the does? Who are the does 1 to 250?
Well, that's they're saying, like, we can just bring people in later and we'll just fill those blanks in later, right? It's like Taylor Swift. I've got a blank space and I'll fill your name in, right? I mean, that's kind of how it works.
Okay. I didn't know about didn't expect a Taylor Swift reference, but that's good for you.
My daughter is a huge fan, and I drove cross country with her, and I got a whole lecture on Taylor Swiftism. So
okay. Well, so here's another one of the. I look, there are many questions here. But let's go back to the 2012 meeting, because I've heard about this. There was a meeting in 2012. But even before that. So who are these NGOs? Who is funding all of this litigation? I know that the New York Times, David Gellis, wrote this flattering profile for a tort lawyer who's, apparently has been called by God to sue the oil and gas industry, which I read with some amusement and a bit of disgust as well, because I thought, well, wait a minute, you could sue anyone for I guess maybe I'm too cynical. You're suing over the weather. Well, how do you know that this gallon of gasoline from this company caused this amount of weather? But before I get to that, who are the NGOs? Where's the money coming from for all this? It sounds to me like some is from the tort bar, but there's other money coming from foundations, NGOs. Where can you name the climate integrity?
Center for Climate Integrity is
Center for Climate Integrity, right? Thank you.
They're the ones that are, involved in and publicly involved in a lot of these, in a lot of these lawsuits and recruiting communities, and they've got various sub-organizations that they use to try to recruit folks. There are other foundations involved. We have a report called Beyond the Courtroom, which is on the MAP website, the MFG Accountability Project.org website, that kind of walks through a lot of this, especially early on, like where some of the, looking at their different foundation reports and kind of who was involved, the Rockefeller Foundation, for one, has played a central role in all of this, which is kind of ironic, I suppose. But a lot of it is just, for them, the ability to bring these lawsuits and leverage the media and leverage the politics around it. That's their victory for now. They just want to file these lawsuits so that they can try to leverage them for these ulterior, outside of the courtroom purposes. And so that's the first thing, is like how many, they talk about successes in terms of measuring how many lawsuits they file. Anybody can file a lawsuit. That's not the hard thing to do. It's, can you win a lawsuit? And so far that hasn't proven to be the case. And so in 2012, it was this kind of a cast of who's who behind, involving all these lawsuits. There were, there are lawyers there, there are the academics there, funded by some of these groups. And they talked about, and I can kind of go through, and this isn't take my word for it. They put out a report on their discussions. And out of that report, they said they still believe the courts are the best current hope for setting their national policy agenda. They said that, again, try to make it look different from AP versus Connecticut. And one person said, even if your ultimate goal might be to shut down a company, you still might be wise to start out by asking for compensation for injured parties. And so and they also talked about in there and then subsequent meetings, the idea of naming the issue or the campaign to try to create outrage in people's minds. And that's exactly the playbook that we've seen followed, since that 2012 meeting.
So this is as much PR as it has anything to do with legal issues. Then is that a fair way to characterize
Absolutely.
it? I looked up it was the lawsuit that was the New York Attorney General brought the lawsuit seeking 1.6 billion. Exxon was represented by Ted Wells Jr. I think maybe you had that right. I'm just but right at the end, apparently the state just said, and Exxon, I'm looking at the headline, called the climate case a joke on the last day of the trial.
That started out as like this big thing, like that they misleading and lying, and a lot of the what we've seen in the media about how they're this narrative that try to create outrage in people's minds, and then it got narrowed down once the court kept saying, well, you haven't shown us enough to to validate that claim, you haven't shown us enough to validate this claim, and the case kept getting winnowed down to finally it was just an investor lawsuit, and ultimately the judge said that the claims were hyperbolic and dismissed the case entirely. And, and so, of all this rhetoric that you hear around these lawsuits, the only court that has actually ruled on that has called it hyperbolic and dismissed it.
So I want to make sure I understand what you're saying. So the New York versus Exxon case was the only one that finally got to trial, and the judge just said, "This is get out of here. This isn't valid." But that's different from the AEP versus Connecticut case.
Yeah, because AEP versus Connecticut, that was the back to the 2011 case went up to the Supreme Court, and then in last year, the New York City brought a lawsuit, one of these current lawsuits against the industry. And that's what got dismissed both by the district court for, because it's not, these aren't valid public nuisance or Consumer Protection Act claims. And then the U.S. Court of Appeals for the Second Circuit agreed and said, went through the whole thing explaining why these aren't viable lawsuits, because that had been filed in federal court. And so the federal courts had what we call jurisdiction over that lawsuit. All the others were filed in state court. And then we had this battle for the last 6 years of who has jurisdiction over it. And now they're all going to state court. So, the goal is to find courts, unlike, with the New York City lawsuit, that won't follow AP versus Connecticut and try to carve a different path.
How is this different from to hear some of the tort lawyers and the way they're discussing it, that they're saying, well, this is similar to the tobacco litigation or to asbestos. How is it different?
Well, I mean, I don't really want to talk much about it, asbestos or tobacco, but what I can say is that, we're talking about a product right now that is essential to modern life. And people may not like that. They may disagree with it. They may not like what the companies have said or done, but but if tomorrow all of these energy sources were to go away, it would just be unsustainable and unrealistic. So as I mentioned before, figuring out how we source and use energy in a way that doesn't impact the climate is the top objective right now. And so we have to work through a process to get there. And these lawsuits don't help. And in fact, they hurt, because what it does, there's a great article in the New York Times about a year or so ago explaining, if all of a sudden all these companies that are being sued were to kind of reduce their focus on developing these products, you've got the energy companies around the world, from China to Saudi Arabia to Russian energy companies that have said, we're going to start increasing our production to make up for anything that these other companies don't do. And so they're looking. So it's not going to have any impact on climate change. It's not going to have any impact on the use of fossil fuels. it just becomes American consumers have to pay more because we're saddling these companies that provide us with energy with more expenses. And while these other companies, the government-owned energy companies from around the world, they don't have the same commitment to producing energies in ways that are environmentally friendly. So if they do more, the environment gets worse. That we're not going to reduce use of fossil fuels, just going to shift it again to there. So we're not going to reduce, carbon emissions. We're going to end up, with American consumers paying more and being disadvantaged, and our companies being disadvantaged for no gain to the larger premise here, which is to do something about climate change.
You were written about in the Guardian. Here's the quote. That Phil Goldberg is, quote, a hired gun for a front organization serving some of America's most powerful oil firms. And it goes on, part of a network of enablers working to preserve big oil's power and reputation as it faces a barrage of litigation. More than 24 cities, states, municipalities allege the industry lied to Americans for decades. Lawsuits demand companies use some of their vast profits to help pay for the human toll of the climate crisis, including the damage brought by rising seas and increasingly severe weather disasters. It's the Guardian, right? But this is, you're being characterized as a hired gun, and a network of enablers. But I think the part that to me is the dissonant part of this is what you just said, that it's not that people choose to smoke, right? Or they need to drive to school, right? They need to drive home. They need to drive to work. So that it's the way the media seems to be portraying this is that, oh, somehow there's an evil industry that's supplying us with a product we can't live without, but we're still going to sue them for it. Am I making that too simple, or am I misreading something here? This is the part that seems to me, in addition to the issue of how do you affix blame for one specific heat wave or hurricane or whatever, but that there's the disconnect between the product that we all have to have, and we talked about this before, and yet somehow suing the company for providing the product we have to have.
Yeah.
This isn't a legal question. It's more of a cultural question, right? But how did we get here? And I know you're a lawyer and you want to focus on the law and the Supreme Court and the rest of it. How did we get to this cultural moment? Because that seems to me to be the broader story here. This is about a disconnect in the culture between something we have to have, and yet we're going to demonize the industry for giving us something we can't live without. How do you think about that?
I mean, I think it's politics. It's people. There are, taking on the industry is certainly popular with some constituencies and some, elected officials, and you have also, those who would stand to make a lot of money if these lawsuits were to be successful. And so when you have that confluence of politically driven ideology with with potential to make money, then a lot of things can happen. And that's one of the reasons why I think these lawsuits are concerning more broadly, is because this playbook could be used against any industry that has products that have externalities. And it's increasingly being used that way. And so, if there's a social or political issue out there, or an environmental concern that's out there, they just want to go sue the companies that were involved in that, as opposed to looking at the issue and saying, what do we really need to do here? And what's the best way to try to drive the outcome, I think, that's beneficial to everybody. And that's the concern. So it's politics, and that's, plain and simple, politics and money.
So you mentioned the Rockefeller Foundation. What are the other, in the Climate Integrity Project? Who are the other NGOs that are involved here? And have you, I know you mentioned the report that tracks their money and all. I didn't look at that one, but what are the other ones that are the prominent ones here? And who else was at this 2012 meeting that you talked about?
A lot of they're the two main ones. I mean, I'm sure there are others that are involved, and we probably name a few more in our report. It's less to me about the people who are involved and more about the broader policy and what they're trying to achieve, and frankly why it's wrong for us, and why it's wrong for consumers, why it's wrong for manufacturers, and frankly why it's wrong policy. And I think that's really what we're focusing on at the Manufacturer Accountability Project, because at the end of the day, that's what's most important, is trying to figure out how we're going to deal with climate change, how we're going to do it the right way, and how we're going to do it in a way that is that is best for the American people. And when you're setting up American energy policy, EPA and the Energy Department and Congress and the administration, they all have to look at all these different factors. They can't just say, okay, because of climate, we want to do this, but there's affordability, there's energy security, which in the past couple of years with, the invasion of Ukraine has become a lot more center stage. There's a lot of factors that go into establishing American energy policy. And yes, climate is one of them, and it's an important one. But there are others that are also important. And what they want to do is take this out of the hands of the people that deal with checks and balances, that deal with all these other things. And they want to have judges say, we're going to make it, we're going to set energy policy because we want to see, more focus on climate. And that's not the right branch of government. That's where we're concerned in saying that's not the way we do democracy in this country. That's not what things are about and how we set policy. Is trying to go around the checks and balances. You should go through the checks and balances because they end up with the better solutions usually at the end.
Well, that seems to me that I'm paraphrasing slightly what you said, but they want to have judges set energy policy, if I'm abbreviating what you said.
But, that's exactly right. They're frustrated that their policies aren't being adopted in Congress and in the federal agencies. And that's true regardless of who's been in the White House or who's been in, who's controlled Congress. They're going back and saying they've never been able to get their policies through. And so they're going to the courts to try to do that. If you go back and you look at the AP versus Connecticut case, it was the Obama administration, his Solicitor General, that explained what the problems are with these lawsuits. I mean, I'll read from their own brief saying that it's impossible to consider the sort of focused and more geographically proximate effects that are raised in this kind of litigation because there's an unimaginably broad categories of both potential plaintiffs and potential defendants, making the question of who to blame capacious. And so, the Obama administration opposed these lawsuits because, this is societal wide. This is 150 years of emissions. These are actors around the world, and it's the world that needs to get together to drive these policy solutions, not a state court judge in any of these states that are, where these cases have been brought.
Well, I like that. For unimaginably broad. I don't know that I've heard that phrase before, but I like those two words together. Has the Biden administration tipped its hand on any of this? Or are they willing to sit on the sidelines? I didn't know that the Obama administration had weighed in on the other litigation, but has any tea leaves reading any tea leaves regarding the Biden administration or what their Solicitor General might do on this?
Well, so their Solicitor General came in and said that they didn't think these cases should go to federal court. In the case where the Supreme Court decided not to weigh in, they'd asked the Biden Solicitor General to say, "Hey, what do you think?" And they said, "Oh, let him go to state court." So that was a change from what the Trump administration had said, what the Obama administration. If you kind of read,
so let me stop you. So. I've characterized this administration. In fact, I just did in my latest Substack, is the most anti-hydrocarbon administration in American history. And I'll stand by that. I think that that's a true statement. That now the Biden administration, in the case that was decided by the Supreme Court in April, their Solicitor General said, "Oh yeah, it's so fine. Go ignore AEP versus Connecticut. This should be handled in the state courts."
Right. That's exactly right. And, because there's certain doctrinal hurdles I was saying before that the defendants would have to cross over. And they went through and said, we don't agree that they've met these hurdles. But I mean, politically, I think it's right that they were voicing some support for this litigation, which frankly is concerning because, again, this is why we need a federal response. This is what we need to have a uniform understanding of. We're talking about blaming for climate change and funding, local infrastructure projects related to climate. This is not a liability issue for state courts to do piecemeal. We need one federal and national solution. And frankly, for those communities that do need money, the Biden administration has made some money available. They've through their various infrastructure programs exactly for this purpose. So that's where, we think the better solution is than doing it through lawsuits.
So would the Biden administration Solicitor General then say, "Oh, well, we'll let this run its course in the state courts," because they didn't think that they would get a favorable outcome in the Supreme Court? Is because given the makeup of the Supreme Court today, is that how do you read that from a political standpoint?
I think that's probably true. I think that they, from a political perspective, and I don't think I'm saying anything out of turn. I think that they wouldn't mind seeing this play out in the media and play out in different sectors and see how things shake out at the end of the day. From a there was a lot of, I think, pressure on the administration to just stay back and let us take this fight. And so I think that's what they decided to do at the end of the day.
Well, there's a word that begins with chicken that I'm not going to use here, but as a 4-letter modifier that comes after. Well, so then what's the next step? Tell me where the Multnomah County litigation is. Where is it now?
It's just been filed. I mean,
especially given the April decision for the Supreme Court. Then, so is it correct then that all these different lawsuits, a couple of dozen of them, can now go forward with discovery, and that would be the next step, or what happens next?
So what happens next is, well, I'm sure there's going to be some procedural issues that come up, but by and large, the next major thing would be that the defendants would say in each of these cases, the law doesn't support what these lawsuits bring. So they're being brought under Consumer Protection Acts, under public nuisance, and you mentioned trespass or RICO or whatever, various theories that they're saying. And the defendants will say, hey, the law doesn't support these allegations. And I expect some will win, some will lose. I mean, it's kind of just, I think a lot of state judges, they're very wary of dismissing cases at the outset because, they also want to see how things progress. And so, I think if they looked at it fairly, they would dismiss the lawsuits because the law doesn't support these lawsuits. But I wouldn't be truthful if I said to you, I think we're going to win all of them. I think that some will go each way. But
the next step then, given this ruling at the Supreme Court, then the next step is for the oil and gas companies, and the coal companies, I guess, because Peabody is included here as well, right, that they're going to file motions for dismissal of all of these cases, and then that will have to run through that gamut of that process, and then the judges will decide, well, either they're dismissed or they can go forward, and then there's battle over discovery, there's battle over depositions, battles over
regular litigation, right? And then, it could be several years before we see anything that kind of gets towards any kind of, substantive determination of the litigation.
And that will have to and then any substantive determination, then you get some kind of ruling. Then if it's negative for the oil and gas sector, then that's when you appeal to the federal courts, because you have the argument. Then it's ripe then for determination in the federal courts, because we're saying, well, the state court didn't see this right, so we're taking it to the federal level.
So they'd have to go to the state Supreme Court or up the state appellate process, whether it's mid-level appellate court, then state Supreme Court. And then once it's the state Supreme Court, assuming there are federal issues, which there are, then they'll petition the U.S. Supreme Court to get involved in saying, hey, you need to look at these because they're misapplying federal law. And so that's what, hopefully this, if we ever get to that point, the Supreme Court would weigh in at that point.
Gotcha. So we're looking at legal fees here that will be enormous. What do you charge per hour, Phil?
My different clients, different things. So it's all.
What's your standard rate?
Honestly, I don't even know. And I'm not being coy. I really don't know.
So you're working on retainer then for the manufacturer's accountability project?
Yes,
then
I am. Yes.
Okay. Yeah. So, but your firm is under retainer then for this?
Yes.
Okay. So how big, what is this going to cost? I mean, if you there's the potential for liability. Multnomah County alone is asking for $50 billion. And they say, I looked at the lawsuit, for the costs of studying and planning on a countywide scale for the renovations, replacements, retrofits, and revised programs that are reasonably necessary to reduce the ongoing harms caused by the defendants, the implementation of which will, and it goes on and on, weatherize the county, prepare for safeguard against continued infliction of harms from the ACC, anthropogenic climate change driven extreme weather events for which defendants are liable. So that's $50 billion. If the damages are awarded, what could the legal fees be here? Just if you think about what the because this is one of the issues that was, as I understand, when and it's germane here because Entergy was owned the Indian Point nuclear plant in New York, and they faced years of litigation. And from what I've been told, they just got tired of paying all the lawyer bills and said this is too much. So I'm assuming you smiled and you blushed a little bit. Okay, I get it. But you're billing for your time. If you're a trial lawyer at your level, I'm assuming it's, hundreds of dollars per hour and close to $1,000 an hour. How much will this litigation cost the oil and gas industry? How much have you budgeted for the Manufacturers Accountability Project to defend against all these lawsuits?
Yeah, I mean, so we're not defendants in the actual cases, and my firm, the big energy companies don't use my firm to represent them. There's different law firms involved, and so I don't know what it costs to defend these kinds of lawsuits. But you're right; it's got to be tens of millions, if not more, every year, given the magnitude of all these cases. Now, there's certain economies of scale because a lot of the same arguments are being made because what the plaintiffs' lawyers have done in a lot of these suits is they basically filed carbon copy lawsuits. So right. There's going to be economies of scale and kind of making the same arguments and filing them in the different the different cases. But it is a big waste of resources. These kinds of resources are much better spent doing something more productive than what we're seeing here.
So I just want to understand what you just said. So Exxon, Chevron, Royal Dutch, Motiva, they're all going to have their own lawyers that are going to be involved in this litigation in Multnomah County. So then if you're the special counsel for the Manufacturers Accountability Project, then are you kind of the general manager for the litigation? What you're telling me here is that you've got a whole cast of lawyers that are going to be responding in Multnomah County. Well, then
right. We don't get involved in the specific cases. We'll file sometimes what's called amicus briefs, for the National Association of Manufacturers in the appellate courts to explain kind of how we see the cases, but we're not involved in managing the litigation or in any way, dealing with the trials. That's all, all the companies have their own counsel and doing that. What our concern is talking to people like yourself, like others who are looking at this and saying, is this good or bad? What should we make of this? And that's where I think because we're not in the cases, we have the ability to talk to people and say, here's why people should be concerned about these lawsuits. And so that's kind of how we've gotten involved. So it's not in fighting the day-to-day battles in the courts.
Oh, okay. All right. Well, I'm glad to make that distinction because I didn't understand. You're involved. You're monitoring the litigation, tracking the litigation, but you're not necessarily filing briefs unless they're amicus briefs into the court but you may file an amicus brief in the Multnomah County case. Then is that right?
If it got to the appellate level, probably that might be true.
Okay. So you wouldn't have anything in the motion at this stage. You wouldn't be filing any briefs and in a motion for dismissal or anything at this level. You would be your role would come later.
That's right.
I see. Okay.
Because typically it's the appellate courts that are looking at the pure legal issue. And that's typically amicus briefs, if anybody is filed, is when they're really just looking at the legal issue.
Right. So when you went through law school, I mean, the stakes here are just staggering, right? If Multnomah County is asking $50 billion and you have 24 other lawsuits and you just, I don't know, 24, that's, if you just say $10 billion each, that's $240 billion. The stakes here are just staggeringly large, not just in monetary terms, but also in terms of the potential harm to the industry, harm to the consumer, cost to the consumer. So when you're going through law school at George Washington, did you ever think you'd be involved in this litigation that is this large? Because this would be potentially some of the biggest tort actions in American history. I'm not an expert on law history, but those are very large numbers we're talking about here. Did you ever imagine you'd be involved in this kind of high stakes litigation?
I never did. I never thought I'd work at a law firm. I was working on the Hill. I was working for a congressman by the name of Steve Rothman and then a congressman by the name of Alan Tauscher, going to law school at night, figuring that was just a good way to advance myself, on policy issues in Congress. And then ultimately decided, to go to a law firm and found a group that did this liability policy work at Shook, and I've been here 20 years. I said, just celebrated my 20th anniversary here at the firm. And so, that I never thought I'd be at a law firm, let alone working on these kinds of issues. And they're, as you said, they're very important. And I'm honored to be able to participate in this and be able to, help explain the concerns that, it's one thing to throw, aspersions and to, try to demonize others. And sometimes it's hard to sit there and say, well, that's not really the way it is or the way it ought to be. And so, I'm glad I'm able to do that here, and I appreciate you giving me time to do that. And hopefully your listeners have, a little more educated on this litigation and what the concerns are about them than they would have been if they just, heard from the other side about, why they should, want to blame others over these important issues.
Have the NGOs, of the climate activists, come after you?
Well, I think you've already covered that.
Well, that was how the Guardian described you, but I mean, have there been other attacks online or other places against you and what you're doing?
Look, I'm sure they're not happy with what I'm doing, but that's not here nor there. I think it's important that we set the record straight and we're out there on these kinds of programs, and happy to be involved.
Okay, so again, my guest is Phil Goldberg. He is with the Manufacturers Accountability Project, which is an arm of the National Association of Manufacturers, which of course is an NGO that represents the big manufacturers in the U.S. You can find out more about this litigation at mfgaccountabilityproject.org. Phil, I think we covered a lot of this. I know we could take a much deeper dive on all of the different issues around product liability. Well, the claims of negligence, fraud, deceit, trespass, public nuisance. But I think we've covered most of the main issues. Let me hit you with the last two questions I ask all my guests. I know you're busy. You mentioned that your daughter, you've been driving across the country with her and listening to Taylor Swift songs. What are you reading? What books are on your shelf? Or do you have time for reading given all the other duties that you have?
Well, actually, it wouldn't surprise you. I did order Bill Gates's book on how to solve climate change, not climate litigation. I thought that was he had interesting perspective on it, and a lot of it was about innovation and that sort of thing. But I will say, my wife is the avid reader in the family. Her night table is usually stacked with 7 or 8 books that she's in some level in, and so I let her take that mantle, and I do, as you can appreciate, do a lot of reading cases and all that during the day. And so sometimes I get home, I just want to turn on the news or turn on something funny and just kind of relax.
Fair enough. I did remember one question I have to ask you. So why aren't any of these plaintiffs suing the coal companies in China? Why aren't they suing these foreign companies? Because it's not just American domiciled companies that are producing, CO2 and releasing it into the atmosphere. That was one that I meant to ask here. So would there be a pathway in court? Where would they, if they tried to hold any of the big Chinese coal companies, or Coal India Limited, which is one of the world's biggest coal producers, or the Colombian coal producers, or Indonesians? There are a lot of other companies in the world who are producing hydrocarbons that are being burned that could also, in theory anyway, be blamed for the weather. Why aren't they suing those other companies?
I think from a political perspective, they're obviously targeting who they want to blame. I think there's jurisdictional issues that would be involved in whether these other these other entities, which are often state-owned entities, could even be brought into U.S. courts. So there's probably some political, some legal reasons why they haven't done that, but you'd have to ask them that question. That's their strategy, not mine.
Got it. My last question, Phil, what gives you hope?
What gives me hope? Well, I'm an insufferable baseball fan, and the Nats are my home team. And 2019 was awesome in terms of the World Series, and I watch a lot of the young players that they've got, and in the draft they just had with Dylan Cruz from LSU, and that gives me hope, because I like to see them get back to playoff contention and hopefully a World Series in the next few years.
Well, I think I've asked that question a couple hundred times down in this podcast, and you're the first one that has mentioned baseball as giving you hope, but that's I'm okay
America's
with that.
pastime. I hope it does give us.
No, I'm not opposed. I think that's fine. I'm a basketball fan myself, but and a Spurs fan, and hoping Wemby is going to turn the Spurs
Well,
around
there
this
you
year.
are. Right.
But we will see.
Hopefully, Wemby gives you hope.
Well, I've answered that question before. That question was for you. So my guest has been Phil Goldberg. Phil, thanks for coming on the Power Hungry podcast. You can find out more about him at mfgaccountabilityproject.org. Phil, thanks for your time. An interesting look at all this litigation. And I have to say, I'm going to wish you luck on it, because if these lawsuits succeed and these damages are awarded, there's chaos will ensue, I think. And I'm firmly hoping that rationality and the law prevails here. So good luck with it.
Well, thank you. Appreciate it. Thanks again for having me on.
And thanks to all you in Power Hungry podcast land out there. Give us a nice 5-star rating on whatever platform you're listening to this on, or you can leave comments, of course, on the YouTube channel. Until next time, for the next episode of the Power Hungry podcast, see ya.